Welcome to Employee Benefit Plans and Business Sense.
Hey everybody, welcome back to an all-new episode of Employee Benefit Plans and Business Sense with Dahl and Kathleen of KLB Benefits Law Group. I'm your host, Mike Leon. Dahl and Kathleen have been helping employers and benefit plan service providers navigate the complex legal requirements of employee benefit plans. And with decades of combined experience in employee benefits law, they work closely with HR professionals to keep plans compliant, cost-effective, running smoothly. All of us have worked in corporate America. You need those plans, right, folks? So look, today we're going to be talking about what every HR director should know about hiring an employee benefits attorney and why having a resource like that can protect both the company and the employees. So ladies, good to see you both. Dahl, I'll start with you here. What should HR directors consider why should they consider working with employee benefits attorney?
Oh, thanks, Mike. The most persuasive reason to hire a benefits attorney is cost. It's cost savings. It's much more efficient to have an ongoing relationship with a benefits attorney who can just help with those specific issues in their company that will help the HR director have a reliable resource for planning, a reliable resource for monitoring their plan, a resource for responding to third-party service providers and not get pressured by service providers to do something that may be more convenient for the service provider than wise for the company, to advocate for the company in those kinds of situations, and to prepare and plan benefits issues going forward. If the company is growing and plans acquisitions, or if the company's considering a large layoff, all the things that would affect the size and shape of a company will affect the size and shape of its employee benefits plans. And it's great to have an attorney on board proactively to prepare for these sorts of things.
And I would also say that, every HR, not every company has an HR director. Hopefully they have someone who functions as an HR director. Sometimes, human resources departments, they cover a huge area of responsibilities for employees, and benefits is just one part. And as we've talked about before, the employee benefit plans are really complicated. And, all the regulations and all the situations that come up. And, ideally, if a company's big enough, they actually have a benefits specialist on their team. And at least that person is sort of more educated about benefits issues specifically. But for the most part, the average HR director or, HR responsible person is not going to be able to have the bandwidth. And they'll rely on other service providers, like their third-party administrator for their retirement plan, or their insurance broker, or other benefits consultants. But none of those people are able to offer legal advice. So, I think, as Dahl was saying, ideally, an employer, their HR director, on behalf of the employer, is going to seek out an employee benefits attorney as soon as any benefits issue comes up. And by a benefits issue, I mean not just, problems that need to be fixed, but any kind of benefits, like they want to start a new plan, or they want to change the design of their plans, or they, there could be a whole bunch of like sort of non-problematic reasons that affect the company's employee benefits, where an HR director should at least, get an employee benefits attorney involved to look at the situation and see where they can add value. And so anyways, I think it's always good to be, in their address book, and so they can reach out and just ask a question, because if they can ask a question now, then, it's probably going to save a lot of cost and angst and problems in the future. So it's just sort of one of those things that I think HR directors may not think of until there's a problem. But we definitely, it's definitely better to bring us in before there's a problem.
Yeah. Well, and I want to expand on that because you just mentioned, and Dal kind of mentioned it as well too. And Dal, I'll turn to you. You mentioned a little bit about the proactivity here. So for that HR professional right now, maybe they haven't worked with an employee benefits attorney before. Explain a little bit more of not only what Kathleen said, but maybe are there other examples of why you should involve proactively an employee benefits lawyer? Can you give some other examples of why?
Yeah, and one example that's very timely these days is is changes in the law. There have been some recent huge pieces of legislation passed in the past few years that have affected employee benefit plans with very large changes. So I would say everybody's familiar with the Affordable Care Act that implemented changes, hundreds and hundreds of changes to the health and welfare plans of the throughout the country over a period of a decade or more is when how long it took to implement all of that. And then more recently, the Secure Act, where there was two different Secure Acts, one that was passed in 2019 and one that was passed in 2022, and both but between them they had over 1,000 provisions affected 1,000 different changes affecting employee benefits in retirement plans, in particular, in their in those two pieces of legislation, and that's in the past 6 years, and those changes are still being implemented. There's a lot of the ground beneath you can shift if you're an HR director in a company. You changes come whether you want them or not, even if you aren't planning to acquire a company or grow or shrink or change your plan design. Congress will change your plan design for you, and you have to be aware of that. So that's another very good example to have an attorney, a benefits attorney, ready to advise you and train your staff or whatever it is that's required to educate you about changes in the law.
And just sort of echoing what Dal is saying, in particular about these changes in law, again, some of these changes are mandatory. And so employers are going to have to deal with them, and how they deal with them, they're going to need guidance. But, because a lot of these changes don't always come with a detailed explanation of how you're supposed to do it. But the other part of these legislations, there are a lot of more opportunities, a lot of optional changes. And so that's sort of, part of what the employer, the HR director, is going to need to think through. And that's part of how we can help them understand what the implications are.
It funnels into this follow-up of like, you mentioned congressional changes, and a lot of people don't read the legislation. That's just not only the HR professionals, that's the American public. But let's talk about like what other events are out there that potentially maybe an audit, maybe a company merger that's happening that suggests to that HR professional that's listening to this, hey, you know what? I should call an employee benefits attorney right away. Dal?
Yeah. Well, here you go. Think about if you had to open your refrigerator for a stranger and have them judge just how clean your fridge is. If you knew a stranger was coming over to your house to look inside your refrigerator, you might clean it ahead of time, right? I would. My fridge isn't always up to snuff. So an HR professional, similarly, if there's any initiation of a contact with a third party that needs to look at your benefits records, you should hire an attorney before you divulge those records to help you get them in order and up to snuff before you have to show anything. So this counts for a government audit. And the two agencies that might audit your plan are the Department of Labor and the IRS. They have different reasons to audit the plan. They cover different aspects of a plan, but they both have a right to come in and ask for, correspond basically with the company and ask for documents and information in connection with the employee benefits. And if you don't have an attorney safeguarding the scope of that inquiry and helping you narrow the scope, get extensions of time to respond, fixing things behind the scenes before you have to reveal them, all of the strategies that lawyers are trained to employ to help their clients. If you don't have an attorney on your side, you might divulge too much. We've been hired by clients partway through a government audit after they've revealed too much, and it's hard to back backpedal. It's hard to walk back a revelation. So it's much more cost effective to hire an attorney right away. And what other third parties would be looking at your plans? It could be if you're if you're getting the company ready to be sold, then a prospective buyer usually gets a confidentiality agreement in place, a non-disclosure agreement in place, and then looks at least the past few years of plan records to make sure that they're not buying a company that's got a compliance problem. And so that's a third party that if you really want to impress. So you should have benefits counsel on board early to prepare for a sale. And of course, maybe even before you go into the market to sell. And other third parties, of course, are people like we talked in the previous podcast about employment lawsuits, and former employees might sue based on all sorts of things, but one of them might be their employee benefits. And it's really good to have, before you divulge anything in a lawsuit or in an ERISA a benefit claim dispute, it's great to have a counsel on board to help you prepare for that response.
And just adding to that, in the sale of the company situation, the same is true on the buyer side. It's good to have a benefits attorney involved in on the buyer's side of things, because that due diligence, really understanding what you're taking on if you're buying this company, which has these employee benefits, particularly retirement, the retirement plan side can be, a big hassle if it's not vetted ahead of time. And, maybe the plan needs to be terminated before the sale is complete so that the buyer isn't taking on all that liability. But you won't really know that, or if the buyer is considering keeping the other plan and merging it with their plan, or, a lot of these things, on both sides of an acquisition. And the other situation is where a plan is big enough that requires an annual audit as part of their reporting requirements, their annual reporting Form 5500 requirements. If they're big enough, then they're going to have an independent audit every year, and auditors are required to go in great detail, and they dig into, they look at, payroll stubs, and they look at, census, and they really, a good auditor will, if there's anything there, they'll find it. And so, I find that we get a lot of reach outs around October, early October, before the October 15th deadline for Form 5500s, when an audit is happening with all kinds of questions and panic and things like that. So I just wanted to add that to what Dahl was saying.
Yeah. And, I got a two-parter here because it's a natural follow-up for both of you. Dahl, I'll start with you. What problems have you seen an HR team that tries to resolve these issues on their own, these benefit plan problems on their own? And then on the flip side, can you share a story where you partnered with an HR on this benefits issue and it led to a better result for the company? So let's start with they try to resolve it on their own, and then give me an example of where you actually helped them.
Yeah, well, thank you. I have many examples, but one jumps to mind, and that is a plan was being audited by the IRS. Probably, it's never revealed why a plan is being audited, but it was likely due to an error on the 5500, which is the annual tax informational filing that's submitted every year. And the IRS caught something in this, an error that made it appear as though the plan had taken a loan had given credit to the company, and it was just an error in the reporting. And what happened was the company had tried to save money by not hiring a benefits counsel, got deep into the audit with several rounds of document production where they were giving documents to the IRS, really just opening their files and just having the IRS get everything that they had. And in fact, the IRS audit was meant to be quite targeted, and was ultimately quite targeted. So the client, without benefit counsel hired yet, just vomited all of their files And all of their, they were so intimidated by the fact that the government was scrutinizing them. Apparently they were impressed. I mean, it is an impressive thing to be audited, but they were giving too much information. It was not, they gave more than what was asked. And they, that was really the main issue. And then when they finally threw up their hands, I'm not sure if maybe the IRS examiner said, maybe you want benefits counsel. I don't know, but somehow they hired our firm to represent them in the audit that was halfway completed. And we were able to walk back the scope of the audit and say, what is it that, the examiner doesn't want to look at every single solitary piece of paper that has to do with the plan. They come in with a particular purpose, in this case, to investigate this purported loan by the plan to the company. And so we were able to sort of get rid of all of the other, I was able to narrow the focus of the audit back to the original intention and say, this other stuff, it's not relevant. Don't worry about it. What you care about, actually, I was able to show, and it was true, that the plan had not extended any credit to the company. There was no such, it would have been a prohibited transaction if they had, but it had not. And we were able to show that. And the client simply, without counsel, they didn't know how to continue the conversation beyond, here are our documents. And so they'd given too much and they didn't know what else to do. And at that point, they hired us, and I was able to have a conversation. An attorney engages with the government, represents the client. The client no longer deals with the agent, except there's an interview. But you basically let the client off, out of the day-to-day of the audit, and you help the agent complete their work. They need to look at these things and see if there's been an abuse, for example. In this case, there wasn't. So I was able to save them from, huge potential penalties, mostly not in the PT. I don't think the IRS would have pursued that line of inquiry, because I think they would have realized that there had been no PT. But in connection with the other things they were about to reveal to the IRS that hadn't been asked, I was able to say, no, you don't need to look at these other years, because there were problems there, and IRS didn't notice them. They would have cared about them if they'd had to look at them, but we were able to just, turn away from those topics. And that was a big savings of money for the client.
Yeah, I definitely think that, particularly in government examination situations, we have so many experiences with, the difference between being there from the very beginning and coming in, down the road when the cat's out of the bag. It's in an audit situation, it's always better to disclose the absolute minimum that's being requested, and making sure that they're, like, if you're giving them some kind of record that they're looking for, that it doesn't have extraneous information that could open up a can of worms. And I would say a lot of times we also, how we kind of add value here for being brought in by an HR director is in a mergers and acquisition situation. I can't tell you. I can't tell you how many times over the last 27 years where there's been an M&A situation and we weren't brought in, and then it's discovered that they didn't terminate the retirement plan, so they now have this second retirement plan, and it may have all kinds of problems with it, and now they are liable for those problems, and they can't just terminate the plan now that they've finished, the deal is closed. So they've got to merge it into their plan, which might be a lovely, beautiful, pristine plan. And so if they're merging this plan with all kinds of problems into their pristine plan becomes full of those same exact problems. So then they've got to clean it up before they can merge it. Or maybe they haven't merged the plan, and the plans have wildly different benefits, and they're now having a problem with their non-discrimination, their coverage testing, because they're maintaining, two different plans with different benefits, rights, and features, and then they're not going to pass the testing. So these are all things that kind of can come up if they don't get a benefits attorney involved on the front end of a transaction. And so it's just a matter of directing attention to these issues, making them discuss them and think about them so they're aware of what they're bringing on when they complete the acquisition with regards to their benefits obligations. So
I was going to say, you got the right to remain silent, right? And not applicable for this. But Don, let me ask you, because you just mentioned it before about in that example that they didn't want to spend on a benefits attorney, right? So for the HR teams that are out there listening to this, they have limited budget. What's the smartest way that they can get legal input without overspending?
Well, I think that the best approach is proactive and preventative. Establish a relationship with a benefits attorney that can be part of your team, where you in-house, added to your in-house team, where you're meeting at least once a year with your attorney. When I say you, the HR team may or may not have a plan committee. We recommend plan committees because they're an excellent way to share the burden of in-house of benefits work. But you have a meeting, whoever's responsible for the benefits inside the company meets with benefits counsel once a year to review things, ask questions, talk about legislation that's been passed, whatever, we would be at your service. And it would, 2 or 3 hours a year can really go a long way to helping prevent problems because you catch past problems early, you prevent future problems, you plan strategically how to change your benefits if you wish to do so, and things like handling audits and all sorts of logistical questions come up that are just unique. It changes year to year. And also, I would put a plug in for having a meeting once a year with the registered investment advisor who is associated with the plan, who is usually hired by the company to advise the company on how to design the investment lineup of the plan. That's a very important stopgap to prevent claims that the investment lineup is inappropriate. So a good registered investment advisor, that's an RIA for short, is part of the team. They're an outside provider who meets with the in-house team at least once a year, and preferably with counsel as well, involved, just to make sure that all of those aspects of the plan are running smoothly. It's much more cost effective to do that as a routine matter than it is to wait for problems to be identified later.
Yeah, definitely. I also would say another way that we can work with an HR director and help them to do it in a cost effective way is working with their other, like their third party administrator, or their in the terms of health and welfare benefits, maybe their insurance broker. And to the extent that it's more cost efficient to have the third party administrator to do some of the, like calculations or record, assembly, but then always having us there to kind of review and oversee and advise, to make sure that everything that's coming out of the third party administrator's records is accurate and is actually going to assist them in the long run. So, we definitely, and any benefits attorney should be able to just work with the team and be able to, sort of outsource some of it where it makes more sense, but always having us available to kind of oversee, verify, and advise.
Well, ladies, thank you so much for the time and insights on all this. We truly appreciate it.
Thank you, Mike.
Thanks for having us, Mike.
Yeah, and thank you to everybody out there listening for another episode of Employee Benefits, Plans, and Business Sense. If you're an HR director and you want to safeguard those benefits plans and protect your organization, do me a favor right now. Visit klblawgroup.com to connect with Dal and Kathleen. For everybody else, please be sure to like, subscribe, review, leave a comment, share this episode with someone who needs to listen to it. As always, I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.